A major development in a years-long legal battle surrounding Oregon's gun laws.
Oregon's long-delayed gun control law went before the state's top court today. Measure 114 is being challenged by opponents who say it is unconstitutional.
Opponents of Ballot Measure 114 filed a petition with the Oregon Supreme Court challenging the constitutionality of the measure.
Now, Measure 114 has been ruled constitutional, but that doesn't necessarily mean it's going into effect, at least not yet.
It's after an appellate ruling. Democratic lawmakers are looking to add gun control bills in the Oregon legislature.
The court's ruling means a hold on gun safety requirements could lift throughout the state.
Oregon just pulled a move that should have every gun owner in the state sitting up and paying very close attention right now. Their state legislature is back in session, and instead of fixing one of the worst gun laws in America, they've decided to essentially rewrite it, slap a new name on it, and hope nobody notices the difference. But here's the thing that makes this truly fascinating. There might be a very calculated reason they're doing this right now, and it has everything to do with a court ruling that could blow the whole thing wide open. Stick with me on this one because the details matter, and what's buried in the fine print of this bill is going to affect real people in ways most haven't even considered yet. Let's rewind for a moment. A couple of years ago, Oregon passed what was known as Ballot Measure 114, and at the time it was widely regarded as one of the most aggressive gun control measures anywhere in the country. The core of that law did something that should trouble anyone who cares about constitutional rights regardless of where they fall on the political spectrum. It took what is supposed to be an inalienable right protected by the Constitution and converted it into a privilege that requires you to get the government's permission before you can exercise it. We're talking about a pre-purchasing licensing scheme, meaning before you can buy a firearm in Oregon, you need the state to hand you a permission slip. Now, since Ballot Measure 114 passed, a few other states have introduced laws that arguably rival or even surpass it in terms of restrictions. But make no mistake, this one still ranks extremely high on the list of the most burdensome gun laws in America. So here's where things get interesting. Enter Oregon House Bill 4145. This bill essentially repeals Ballot Measure 114 and replaces it with a new framework drafted by the state legislature. Now, you might hear the word repeal and feel a moment of relief, but hold on, because what replaces it is not exactly a victory lap for gun rights. The very first line of the bill's legislative intent says it plainly. Section 1 of Ballot Measure 114 is repealed. Sounds great on the surface, but what follows is a legislative replacement that carries forward the same fundamental concept. You still need government permission to purchase a firearm. Is it slightly less terrible than the original? Well, think of it this way. If someone punches you in the face 3 times and then offers to only punch you twice instead, technically that's an improvement, but you're still getting punched in the face. That's essentially what House Bill 4145 represents for Oregon gun owners. Now, here's one of the most significant changes, and honestly, this is the part that reveals just how poorly thought out the original ballot measure was. Under House Bill 4145, the date by which Oregon would mandate pre-purchasing licensing gets pushed all the way back to January 1st, 2028. Think about what that means for a second. When Ballot Measure 114 originally passed, the enactment date was roughly 90 days after the governor signed it. The state was supposed to have this entire licensing infrastructure up and running in about 3 months. And guess what happened? They were nowhere close, not even in the same zip code as ready. The infrastructure wasn't built, the funding wasn't allocated, the organizational framework simply didn't exist, so the date got pushed back, and then pushed back again. And now we're looking at nearly 2 more additional years before this system would theoretically go live. Nobody's complaining about the delay itself, but what it exposes is just how reckless the original measure was. The state created a massive bureaucratic licensing requirement without any plan for how to actually implement it, and without setting aside a single dollar to fund it. That's not governance, that's a wish list with a signature on it. But let's dig into what this new bill actually changes in terms of how the licensing would work, because this is where the day-to-day impact hits real people.
There's essentially no way to prove that, and so millions of Oregonians are now presumed criminals by their state.
Those who oppose this can appeal the law within the next 35 days.
I think it's a 6 in one hand, half a dozen in the other hand proposition.
But these laws are not in place just yet. Lawyers representing the gun owners say they plan to bring this to the state Supreme Court.
Under House Bill 4145, a person would apply to what the bill calls a permit agent for a permit to purchase or otherwise acquire a firearm. So now Oregon is going to have designated permitting agents. And who those agents are depends entirely on where you live. If your residence is in an incorporated area, meaning inside city limits, you'd have two options. You could apply through the police chief of your city or through the county sheriff. However, if you live in an unincorporated area, meaning outside city limits in a more rural part of the county, your only option is the county sheriff. There's no alternative for people in rural Oregon, and there are a lot of them. This could mean significant travel and logistical hurdles just to submit an application for a constitutional right. Now here's the part of this bill that I really need you to pay attention to because it contains a provision that could catch a lot of people completely off guard. The qualifications to receive a permit have been amended, and one change in particular stands out. Under House Bill 4145, a person is disqualified from receiving a purchase permit if they have been convicted within the previous 4 years of a misdemeanor involving violence as defined under Oregon Revised Statute 166.47. When most people hear misdemeanor involving violence, they immediately think of domestic violence offenses, which already carry federal firearms prohibitions. But here's what makes this different and frankly alarming. Oregon Statute 166.47 doesn't just list domestic violence misdemeanors, it includes any misdemeanor assault. That means if you got into a bar fight 5 years ago, or a scuffle in a parking lot, or an altercation at a sporting event, and you were convicted of a simple misdemeanor assault that had absolutely nothing to do with domestic violence, you would be barred from obtaining a purchase permit for a minimum of 4 years. 4 years where you cannot legally acquire a firearm in Oregon because of a bar fight. This goes well beyond what federal law requires and creates an entirely new class of prohibited persons at the state level, at least when it comes to purchasing. And the timeline for actually getting your permit approved, that's getting worse too. Under the original Ballot Measure 114, the state had 30 days to process your application. Under House Bill 4145, that window doubles to 60 days. 60 days before the government decides whether or not you're allowed to go exercise a constitutionally protected right.
A lot of people are saying that this is unconstitutional, and that's why they're filing these lawsuits and motions.
An Oregon appeals court has reversed a lower court ruling after Measure 114 was ruled constitutional.
It could take weeks or months for that court to ultimately decide Measure 114's constitutional in whole or in part.
Decision, frankly, after reading the opinion, it would not surprise me if the state's attorneys want to appeal it as well.
There's a phrase that gets used a lot in Second Amendment discussions, and it applies perfectly here. A right delayed is a right denied. When you have to wait 2 months for bureaucratic approval before you can make a lawful purchase, that's not a right anymore. That's a privilege being dispensed at the government's convenience. Oh, and the cost. Nearly forgot about that little detail. The original permit fee under Ballot Measure 114 was set at $65. House Bill 4145 raises that fee to $150. That's roughly a 130% increase for a permission slip to exercise a right. And yes, the bill does carve out exceptions for law enforcement officers, both on duty and off duty, exempting them from both the permitting requirements and the magazine capacity restrictions. But for the vast majority of Oregon residents, that exemption means absolutely nothing. So the big question becomes why? Why is the Oregon State Legislature doing this now? Why repeal one deeply controversial measure just to replace it with something that's functionally very similar? And this is where things get really strategic and where you need to understand the legal chess game being played behind the scenes. There's a case currently before the Oregon State Supreme Court called Arnold v. Kotek. This case directly challenges the constitutionality of Ballot Measure 114, and it was argued exclusively under the Oregon State Constitution, specifically Article 1, Section 27. This was a deliberate and very smart strategic choice by the plaintiff's attorneys. Under Oregon's own constitutional standards, the only permissible restrictions on the right to bear arms that have historically been upheld fall into 3 narrow categories: manner of use, manner of possession, and restrictions on certain dangerous individuals. That's it. And when this case was argued before the state Supreme Court, multiple justices expressed significant skepticism about whether Ballot Measure 114 could survive that constitutional test. The oral arguments took place on November 6th, and a ruling could come down at any time. So here's the theory that's gaining traction. Does the Oregon legislature believe that by repealing Ballot Measure 114 and replacing it with House Bill 4145, they can render the Arnold v. Kotek case moot? If the law being challenged no longer exists, maybe the court has nothing to rule on. That might be the thinking. But here's the problem with that strategy, and it's a significant one. The constitutional principles at stake in Arnold versus Kotek don't disappear just because you swap out one bill for another. The same legal standards that apply to analyzing Ballot Measure 114 under Article 1, Section 27 would apply with equal force to House Bill 4145. You can change the name, you can adjust the timeline, you can shuffle the permit agents around, but if the fundamental structure of the law, pre-purchasing licensing that converts a right into a government-granted privilege, is constitutionally infirm under Oregon's own constitution, then dressing it up in new legislative clothing doesn't fix the underlying problem. The moment that ruling comes down from the Oregon State Supreme Court, the legal landscape could shift dramatically. And if the court finds that the core concept of pre-purchasing licensing violates Article 1, Section 27, then House Bill 4145 would be standing on the exact same crumbling foundation. For everyone in Oregon, this is the time to be engaged. This is the time to understand what's happening in your state legislature, to read the actual text of House Bill 4145, and to make your voice heard through every channel available to you. Contact your representatives, show up to hearings, support the legal organizations fighting these battles in court, because the rights at stake here aren't abstract concepts, they're the practical, everyday ability of law-abiding citizens to protect themselves and their families. And for everyone watching from other states, pay close attention to what's happening in Oregon, because legislative strategies like this one, repealing a challenged law and replacing it with a near-identical version to dodge a court ruling, could easily become a playbook used in your state next. The fight over the Second Amendment isn't confined to any single state. What happens in Oregon has implications everywhere. Stay informed, stay engaged, and above all, make sure you understand the laws that apply to you wherever you are, because knowledge isn't just power, it's protection. That's it for today, folks. See you in the next video.